Good evening. Welcome to the National Archives. My name is Kimberly Reed, and I'm our Public Programs Coordinator. Before I introduce our speaker, there are a few housekeeping items that I want to note. If you have a cell phone with you, please take that out and turn it to off or vibrate so that it does not go off during the program. In addition, if you need to use restroom facilities during the program, if you step out the doors behind you, turn to your right. You might have noticed extra lighting and cameras are with us this evening. Tonight our program is being filmed for C-SPAN, American History Television, so please check your local listings for a future air date. This evening we mark the 70th anniversary of the Nuremberg Trials as we present our program in partnership with the Truman Presidential Library, the Truman Center at the University of Missouri, Kansas City, the Midwest Center for Holocaust Education, and the U.S. Army Command and General Staff College. Tonight's program speaker, Dr. Mark Hull, is an associate professor at the Command and General Staff College at Fort Leavenworth, Kansas, where he teaches the advanced trial course, War Crimes, Law, and History. He earned his undergraduate degree from the Citadel, his doctorate from the University College Cork in Ireland, and Juris Doctorate from the Cumberland School of Law. Prior to teaching at the CGSC, Dr. Hull worked as a criminal prosecutor and served as a brigade intelligence advisor with the U.S. Army Military Transition Team from 2006 to 2007 in Iraq. His books include Irish Secrets, German Espionage in Wartime Ireland, and he has written numerous articles and reviews on various topics ranging from persecuting war crimes to military intelligence. He is an elected fellow of the Royal Historical Society. Please join me in welcoming Dr. Mark Hull this evening.
Thank you. Thank you and welcome. I'm kind of glad they scheduled this talk tonight rather than during the World Series because I have a feeling that most of you would probably not be here. The talk I'm going to give tonight is, the nature of it can be complex. I'm going to try to keep it from being disturbing, but it is serious. And I'd like you to imagine me tonight as a lawyer trying to make a case. And the case I'm going to try to make to you is why this is profound, I think why it's important, and why you should think it's just as important, maybe more important in 2015 as the trial was in 1948 when it finished. In fairness, though, I should probably tell you a story. Last year, I had the honor of going to Nuremberg. And for somebody who does, a lawyer who does Nuremberg trial stuff, this was wonderful. I was the guest of a Bavarian Supreme Court justice, and I got to go to courtroom 600 and spend time just there. We went around. I got to look at the place where this trial happened. And after we were finished, we went to the back room, which is the one on the right-hand side there. And it's where the justices gathered after the trial to consider their verdicts. And I sat down, and the judge brought me over a book, and it was the Distinguished Visitors book from the Palace of Justice. And I'm looking through, and it's got prosecutors and presidents and people have signed this thing. There's some incredible signatures in it. And she said to me, well, I'd appreciate it if you'd write something. And I froze because I had nothing. It's sort of like, if you could, can you do profound on, click of your fingers? And I had nothing. And I'm figuring, be cool, best wishes, Dr. H is probably not going to get the job done. So while I'm desperately, and I just have this deer in the headlights panic, I think, okay, I can buy myself a couple extra seconds, and what I'll do is I'll write this with my fountain pen. And that plan starts to go okay until I look down at my hand and realize the pen has exploded, and I have ink all over my hand, and I'm getting ready to put this down on the Distinguished Visitors book from the Palace of Justice at this place that I've wanted to be for my whole life. And the moral of the story here is, if you're expecting me to be profound, you may go home with ink in your hands. I guarantee nothing. The trials, specifically the subsequent trials, are distinguished from the main military trial of the International Tribunal. A lot of people don't know that one even happened. And if you can find people that know the IMT occurred, was 45 to 46, it's where Goering was tried, it's where Hess was tried, it's where Speer was tried. The chances of you finding somebody that knows that there were 12 trials afterward is pretty remote. And I'm going to pick what I think is the most significant of these specifically to talk about tonight, the Einsatzgruppen case, for a variety of reasons. That's the main IMT. Goering is seated at the far left. It is an international tribunal organized by the four great Allied powers, the US, the Soviet Union, Great Britain, and France. It's the one that drew the most attention. It revealed for the first time the degree and the extent of Nazi crimes during World War II. And the trial has a lot of different purposes. One of the purposes is educational. It's supposed to tell people what happened with documentary evidence in a judicial, legalistic format. Other part is perhaps political. It's designed as a springboard to the new United Nations. It's designed as a vehicle to help a new Germany take the place of the Germany that's just been destroyed. It's designed to set, again, a documentary record so that anytime after 1946, no one with a right mind can ever deny what happened during the war. But when the trial finishes in 46, the second set of trials occurs. And there's two figures in particular that, again, most people have never heard of. If you start to think about great or famous American trial lawyers, you probably heard of Clarence Darrow. Everybody's heard of Clarence Darrow. Clarence Darrow, again, is probably the most famous trial lawyer we've ever produced. I think one of the best is the guy on the left here, Telford Taylor, General Taylor. He was a prosecutor at the main trial at the IMT, and he's the architect and sort of the founding father of the 12 subsequent trials. So the stuff that we talk about tonight is going to be largely the result of Taylor's vision and his insistence on some of these things coming out. He's also somebody of extraordinary moral courage. He's one of a handful of people that in the 50s under McCarthy, he probably cost himself a Supreme Court judgeship or justiceship because he spoke out. The other guy on the right is Ben Ferencz. Ben was the prosecutor at the Einsatzgruppen case. When he took the case, he was 27 years old. He'd never tried a case in his life. He'd never been in a courtroom before. And we made him the chief prosecutor for the Army for the Einsatzgruppen case. He's also one of the kindest, most generous people I've ever met. Ben is 95, he's still alive. He is sharp and has a better memory and better recall than I'll probably ever have the rest of my life. Just a good guy, great lawyer, and he also is one of the architects of what we're going to be talking about. When I do my classes for war crimes, I show them this picture, and it's one of the most terrifying things I think I've probably ever seen. And it's terrifying in a lot of different ways. The picture is taken in the southern Ukraine in September 1941. The person, the NCO there with a pistol who's about ready to kill this man is a member of what's called Einsatzgruppe D. Everybody, all the other Jews of a town called Finitsa are laying in the ditch in front of him. There's about 30,000 of them. The Einsatzgruppe, the SD, thought this was so singular that to capture the moment of execution of the last of the Jews of Finitsa, that the slogan on the back is Die letzte Jude von Finitsa, the last Jew of Finitsa. And again, it's a horrible thing. It's horrible for the person who knows what's going to happen because he sees everybody in front of him that's dead. But just as scary to me, in a lot of other respects, are the people in the background. You have members of the Einsatzgruppe there. You have members of the German Army that are there. There's a guy, second to left, front row, he's in the German Army band. You have members of the Reich Labor Service. The people you don't see in the picture that would have also have been there are people from the local village who came out just to watch. It's a terrible thing. And it's, to my mind, sort of narrows the scope of what happened and what we're going to be talking about. The reason the Einsatzgruppen case occurred, of the 12 trials that are planned after the main IMT trial, something happened during the main trial that made this almost inevitable. One of the prosecution witnesses is an SS general named Otto Ohlendorf, this guy. He was captured by the British in 1945. He talked absolutely freely of what happened during the war and what he did. He commanded one of the Einsatzgruppen. His testimony was used by the prosecution with Ohlendorf's cooperation during the main trial against the other German defendants. He testified on the stand that his Einsatzgruppe had murdered 90,000 people. He's upset at one point because another Einsatzgruppe commander had claimed more people murdered, and Ohlendorf is saying, no, he's just exaggerating. I killed many more people than he did. So, with Ohlendorf's testimony on the record, you had the beginnings of a case that could be devoted entirely to the Einsatzgruppe, because at this point, the Americans and the British really had decided that joint power trials are probably not something we want to be involved in. So the decision was made for the Allies to separate the judicial process, and they're going to continue to try war criminals, but separately. So the 12 subsequent trials, the doctor's trial, the IG Farben trial, the ministry's trial, the high command trial, the Einsatzgruppe trial, are going to be entirely under American, and specifically American Army jurisdiction. But Ohlendorf, and we're going to see him again, is going to be a continuing participant in the story. Because there's something disquieting about who he is that I want to come back to at the end when we talk about, I think, why this trial is important. Now, combined with Ohlendorf's testimony during the main trial, this occurred in early 1946, the lawyer, Ben Ferencz, who had actually, he'd been enlisted in the Army, he'd been discharged in 1945, gone back, he was a Harvard graduate, had been recruited to come back and work for the Army for the Office of War Crimes in Berlin. While he's in the Berlin Documentation Center, which is where we brought all the captured Nazi documentation, SS records, party records, Foreign Service records, everything, he's looking through the records, which is no easy task because there are tons and tons of them, and of course none of them are in English. They're all in German. He uncovers the reports sent back by the different Einsatzgruppe from the East. And Ben says that he actually, once he started looking at the figures and the tabulation, he went and got a calculator, hand calculator. And when he reached a total of 1 million people, he called Taylor. And the combination of Ohlendorf's testimony at the IMT plus Ben Ferencz's discovery of these documents is what made the Einsatzgruppe case mandatory. Now, the way the case is organized is kind of interesting. And the legal philosophy is unique in a prosecution, or at least I've never heard of one, never been involved in one which ever did this. This trial lasts 8 months, from September 1947 to April 1948. Out of all those days of testimony, the prosecution takes 2 days. They put on no witnesses. Think about every courtroom drama you've ever seen. I mean, that's part of the thing, right? I mean, you direct, you cross, you do stuff. That's not happening here. The only people on the stand for the prosecution are the documents custodians that are reading into the record the SD or Einsatzgruppe reports, of which there are many, and the testimony of people who testified either during interrogation or testified at the main trial. So as far as the prosecution's case is concerned, the Einsatzgruppe trial turns into a cross-examination fest. For a trial lawyer, this is just like the coolest thing ever. And I've been advised, by the way, that there are things that trial lawyers find cool that normal people don't find cool. But this really is. And the idea of, you don't have to worry about, direct testimony and prepping that, but you have to be prepared to cross-examine every one of the defendants, assuming they choose to testify. The procedure with the IMT and with the subsequent trials is a little bit different than maybe you're used to. Defendants do not have to testify, but defendants also are interrogated and interviewed before, as soon as they're captured and there's no attorney present. They talk freely for different purposes. And here in a few minutes we'll talk about sort of the categories I think their defenses broke down into, and some of these are very interesting. Because one of the things that has puzzled me and still puzzles me is how you get people to commit the crimes that these people have committed. In fact, I suspect probably on a greater scale than even Ben Ferencz could prove. The Einsatzgruppen were formed at first in the invasion of Poland in 1939. There were 7 of them. The Einsatzgruppen, it's a collective noun. The Einsatzgruppen were numbered 1 through 7, but by the time the invasion of Russia happens, actually a little bit before the invasion of Russia, there are 4. Einsatzgruppe A, B, C, and D. Heydrich, who is the chief of the SD and Heinrich Himmler's deputy, is the guy running point for the Einsatzgruppe. They're assigned to German Army commands. So Army Group A in the north has Einsatzgruppe A. Army Group B, Einsatzgruppe B, and so forth. Einsatzgruppe D is assigned to 11th Army in the Crimea. Their mission and their recruiting takes place, again, early 1941, before the invasion. The members of the Einsatzgruppe are, in every respect you can imagine, absolutely ordinary, which is one of the things that makes this thing so difficult. They are trained. Their task is literally, by the time we get to 1941, to act as mobile extermination squads to go wherever they can go in the occupied Soviet Union and murder people. They are meticulous record keepers. They will submit, actually every 3 weeks, they submit different reports on the numbers of Jews that have been killed back to headquarters. I've got this big book sitting on my desk at work. It's called the Crime Classification Manual. It's prepared by the FBI. And it's designed for every violent offense to tell you the kind of offender you could probably expect. None of these people fit any of those categories. They are, if you had to pick the kind of person likely to commit a mass murder, none of these people would fit that category. Of the Einsatzgruppe leaders, just from Einsatzgruppe A, you have 17 officers. 9 of them have doctorate degrees. You have an opera singer. You have accountants, you have lawyers, you have medical doctors that are serving as head of these mobile extermination units. How does that occur? This isn't the crazy person with a weapon that you kind of think might do this sort of thing. They're exactly the kind of people you think would never do this kind of thing. They're professional. None of them have a criminal record. The ones that live on later, none of them ever commit a crime. There's one exception, by the way, one of these guys. How is that even possible? And the sad truth of it is it's extremely possible. In fact, it's even likely. But as you're continuing with the prosecution of the case, you're not prosecuting the kind of offenders you normally prosecute. These are highly intelligent, highly adaptive, smart people who are going to concoct stories, in most cases, to try to obscure the truth. And as Ferencz's job, you've got to break that. The one exception to the criminal record rule is Naumann, who is this guy in the bottom right. He was afraid of being captured by the Americans, so he murders his driver and assumes his identity. The worst of this group, certainly Ohlendorf, who's down on the bottom next to Naumann, He's a doctorate of law. He's an economist. Everybody who ever met him, including the prosecuting attorneys and the judges, commented how intelligent and well-spoken and reasonable. All of these people are psych tested while they're in custody. All of them come back normal. The only thing that distinguishes them is the fact that they all self-selected for the SS. And you can probably draw some reasonable conclusions from that. You don't volunteer for SS service unless you're an anti-Semite. Just like you don't volunteer for service in the Ku Klux Klan unless you hate people. That's the distinction. This is a map of some of, not all of, the sites where the Einsatzgruppen massacres occurred. They're everywhere. And one of the advantages the prosecution has when you're using the documents of the defendants themselves, and of course, again, the beauty of that strategy is it's impossible for them to deny this. And even the defendants authenticate the documents. Yes, that's my signature. Yes, that's the report I submitted. Yes, that total is correct. And Ferencz also observes, too, that it almost seemed that they were offended by the idea that somehow their math wasn't right. That was almost a worse offense than anything else. The map on the left-hand side accompanied a situation report from Einsatzgruppe A. So the Baltic states, northern Russia, the upper extremity of the map, Judenfrei, means there are no more Jews left there. And as you go down, you can see the numbers of killed that Einsatzgruppe A is reporting. So from that center left section, 136,421. And this is just like a normal situation report. And obviously, if you're submitting reports of this kind in the open, you're not worried about the reception it's going to get on the other side. This is called the Jaeger Report. It's essentially an added total, date by date, place by place, numbers of people that are killed. It's there for everybody to see who wants to see it. This is also entered as prosecution exhibit. And there was a fascinating book, if you haven't read it, you probably should, called Ordinary Men by Christopher Browning that came out a while ago. And it documents the experience of a police battalion 101 in this extermination campaign in the East. And the question Browning asks, and again the question that the trial judge is going to ask, is again, what is going to motivate you? Why are these people doing these things? Because their photos sent home look just like snapshots anybody would send home. Except they're taking other kinds of photographs that aren't in general circulation, and there are a lot of them. The photograph on the left-hand side is from Einsatzgruppe C. The more I looked at this picture, the more something looked kind of weird to me. And the weird thing is the person standing with their back to you on the center of the panel. It's a woman. She's a police reservist. And there's just no end of these, and we're not going to do any more of them because it's bad enough that this stuff has to live in my head. It doesn't need to live in yours. But it's absolutely, there's no denying this. This is a scale that is unthinkable and even unimaginable, and is part of the problem when you're presenting the case. Because Ferencz says at the outset, in the opening statement to the Einsatzgruppe jury, or excuse me, the judges, we're dealing here with a number that is almost beyond comprehension, and it is beyond comprehension. The judges can make a difference in any trial, and you have an interesting one of these here. The senior judge is a guy named Michael Musmano. He's from New Jersey. I'm sorry, my bad, Pennsylvania. Joe, that's just for you. He is the kind of judge that trial lawyers hate. Because if he doesn't think you're doing a good enough job questioning a witness, he's going to take that over for you. If he just wants to know something and that isn't on part of one of the questions you'd plan to ask, it's okay. He's going to break in and ask the question. And Mikey will go on for a while. Meanwhile, Ben Ferencz, or the German defense attorney, is just sitting there watching, the train accident happen, and there's really nothing you can do about it. The two other judges, Spite, who's from Alabama, and Dixon from North Carolina, if they said anything or made any contribution to the trial, the record does not reflect it. This is Mike Musmano's show. He is the center of attention. He will make sure the attention is on him. He talks to the press a lot. He goes to the Eichmann trial in 1961 to try to sell a new book he's written. The most famous thing with Mike Musmano, besides, and there is some good stuff here too. I mean, it's not totally, negative. When the defense is trying to introduce evidence that frankly is pretty extraneous and irrelevant, Ben Ferencz objects. And Mike Musmano gets on his soapbox and he says, listen, I will allow any evidence whatsoever to include the sex life of a penguin if I think it's relevant. And at the end of the case, the German defense attorneys actually gave him a small little bronze statue of a penguin, just as a reminder. But he's a difficult personality, but on the positive side, one of the things Mike Musmano is trying to do during the trial is answer the question that a prosecutor simply probably doesn't care about. Motive. I don't have to prove motive. I have to prove intent. Motive is a separate animal. Motive is nice if you can do it. If you can't, it's fine because the elements of the crime don't call for it. Musmano will ask the same sorts of questions for each of these 24 defendants that appear at this trial. Why? What's your belief? Why did you think that? And some of them will be evasive, and some of them won't. But he doesn't let them off the hook until he gets some sort of an answer. And just preserving that on the record is an extraordinary achievement, and it's still very useful right now. And to kind of go back to the defendants in this case, we start out with 24 that are indicted. Why do you think it's 24? This is audience participation night, so you get a chance to say.
24 hours in a day.
No, but okay.
They were the most egregious?
That's at least partially right, because at least the ones on trial were at least the senior people that they could find and arrest.
They were the ones that bragged about it?
Most of them did, or at least some of them did, but that's not the answer either. The answer is actually kind of simple mathematics. There are 24 seats in the defendant's box at Nuremberg. So you don't have 25 because otherwise you get a folding chair and that ain't going to look very good. So 24 defendants. In the main trial, every one of the subsequent trials, the cap is 24 because that's how many you can seat. And as luck would have it, again, most of the senior, but not all the senior Einsatzgruppen people are brought here. And the decision, of course, is made by the prosecution. We're going to take this as essentially like an organized crime case. The people doing the shooting, in some cases they are these defendants, but in some cases they're not. The idea here is to put on trial the responsible parties, but the nature of the trial again differs from the IMT. At the trial, where Goering and Speer and the rest of those people, none of them ever killed anybody with their hands. They're people in an office that are ordering the killing of others. The people in this box, these 24, are there. They're at the sites. They're at the pits. Later when they're experimentally using gas fans to murder people, they're there. And that's the difference. And again, it really puzzles me again that people know about the one trial and they don't know very much about the trial where the actual killers are being brought to justice. The defendants in this case are, again, an interesting mix. They're atypical. Their defenses break down into three rough categories. About a third each, the math is not perfect, but that's close enough. A third of them are going to justify on the witness stand exactly what they did, and they're going to tell you what they did. They're not going to hide from it. They're not going to quibble about numbers. Absolutely, that's what's in the report. That's what we did, and so forth. Some of them will say that they did it, this is the justify group, because it's well known that Bolshevism or communism is a mortal threat to Germany. It's well known that all communists are Jews, and therefore it is perfectly legitimate to kill them as sort of a preventative measure before they can destroy Germany. When specifically asked about, well, how can you then justify killing women and children, the answer is, well, they're going to grow up and seek revenge. So our action is perfectly justified if your ideology is on this track. Others will say, well, defensive of necessity, that case, or self-defense. If I didn't carry out this order, I would be arrested or killed. You know, there's not one instance of anywhere of that ever happening. Germans actually in the 70s, they went back and they looked at court-martial records. There's not a single case where anybody on any Einsatzgruppen unit ever asked to be let go and was punished. Because some people did ask to be let go. So that also fails. Or if I didn't do it, they would bring in somebody even worse. It's extraordinary, but that's what they did. Group 2, the deny group, wasn't me, I didn't do it, I wasn't there, the numbers are wrong, you can't prove I was there, I was on leave when that bad stuff happened. Just flat out deny. If you've got a document, that's not right, that was just somebody boasting, that didn't really happen. So flat out, not going to cooperate, not admitting to anything. Ohlendorf, by the way, is very, very vocally in the first group. Here's what I did, here's why I did it. That's it. Group 3 is in some ways more interesting. Group 3 is people that will grudgingly, to some degree, admit what they did, but there seems to be some sort of conflict. Some of them kind of have a late case of remorse. Some of them, not all of them. And they're difficult to fathom. It could be very, very easily a trial strategy because this worked really well for Albert Speer in the main trial. Speer famously copped to, you know, I really feel guilty and terrible about what I did and what was done, and Speer saved his life when he probably should have hanged. But in this case, there's one of the worst offenders at the Einsatzgruppen case is an officer named Paul Blobel. Blobel is the person who masterminded the Baba Yar massacre in 1941. 33,000 people were killed over a period of 2 days. He is an unrepentant killer, in a sense. He suffers from severe alcoholism. He's suffering evidence of personality disintegration by the time we get to this trial. After the Einsatzgruppen units are wound up, he's sent back into occupied Russia to burn the evidence of their crimes, to destroy the physical remains. And he really is somebody, if you had to pick somebody on a poster for needs hanging, Blobel's probably a good guy. Ironically, when the decision comes out, we'll get to that here in a bit, the second group, the deniers, none of them got the death penalty. Turned out to be a pretty workable strategy. And because it seemed clear that again, Mike Musmano is the driving force of the judges, to him, he needed a confession. He needed you to admit on the stand that, yes, I did it, yes, this is accurate, yes, this is true, and only in that way, because he'd actually been a death penalty opponent before the trial, kind of turns into one again after the trial. So I think in his own mind that he could only justify giving out a death sentence to somebody who had flat out admitted it. The evidence against every one of these defendants is overwhelming, whether they admitted it or not. And think about how fun the justice system would be if you could only sentence people that said they did it. Again, Ohlendorf is the star. And as a again, even as a defendant in the case, he's acting more like a prosecution witness. He will testify against the others. And if they say something that's wrong, you can call Ohlendorf back up to rebut the testimony. The rules of evidence at the IMT as well as this trial are whatever the trial judge says they are. There is no written guideline. You can only admit evidence under these conditions or with this authentication. It is whatever the trial judge determines to be relevant. So if you want, you can bring Ohlendorf back a lot. And they do. Because he's a perfect witness. He's a weird man, and there's a little bit more weirdness coming from him. After 8 months of testimony, when this case finally wraps up, the written opinion of this that Mike Musmano writes, and if you read a lot of Mikey Musmano stuff, this is him writing the case. Again, the other two guys, I don't know what they're doing during the writing phase, but they're not doing this. He's remarkable. Penguin stuff aside, I mean, this is a guy who actually seems to get it and understand why it's important and gets the right words to explain to other people why it's important. The defendants are not charged with planning or killing through channels or sitting in an office. They're in the field taking an active part in the bloody harvest, and that's exactly what this is. These are guilty people. The evidence overwhelmingly proves them to be guilty, and at least some of them are going to get sentences commensurate with that level of guilt, but not everybody. When the verdict's delivered, 10th of April 1948, out of 22 defendants, and again we started with 24 because had 24 chairs, one of them had committed suicide. One guy had severe Parkinson's disease, and he had kind of a wig out when they were doing reading the indictment, so they shunted him aside. So we proceed with 22. 20, and you're accused, by the way, on 3 counts. I should have said that earlier. War crimes, crimes against humanity, and membership of a criminal organization. The IMT, which is again a remarkable trial, and I hope maybe you ask me back to talk about that sometime, said that organizations, just like people, can be determined to be criminal. So at the IMT, they declared the SD, which is the parent organization of the Einsatzgruppen, part of the SS, the Gestapo, the Nazi Party leadership, and so forth, to be criminal organizations. That decision is final as of 1946. So all you have to prove at this trial, by the way, if you want to convict somebody in count 3, let me see your membership card, and you're guilty. 1, war crimes. 2, crimes against humanity, what's eventually going to evolve after the war into genocide. 20 of these people are guilty in counts 1, 2, and 3. 2 people are guilty only on count 3 because the trial judge determined their participation did not rise to the level of guilt on count 1 and 2. 14 out of 22 are sentenced to death. 2 get life. 5 get imprisoned for anywhere between 10 and 20 years. 1 person is sentenced to time served because really he wasn't the best defendant in the world to pick, but hey, you got to fill 24 seats, so you get who you get. And here's the weird part. Ohlendorf, the SS general, who started the ball rolling on this thing back at the IMT trial, after he is sentenced to death, he continues to go to other trials to testify there for the prosecution. After he's gotten a death sentence, he will volunteer to go testify in other cases, one of the other subsequent Nuremberg trial cases. And it's hard to get your mind around that, but it seems pretty clear that Ohlendorf thought, like some criminal defendants now, the more they talk, the better chance they have of convincing you what they did was right. People under interrogation do that all the time. You get people that you can't shut them up because they really are convinced that the more they talk, the more you're going to believe them. And he continued to do this for years. Very upfront, very accurate, and he's guilty as hell. The problem with the Einsatzgruppen case, and maybe there are a couple of problems. I recommended a book to you earlier, which is Ordinary Men by Christopher Browning. I'm going to recommend a movie to you now. A lot of you probably seen it. If you have, go see it, go get it, see it again. If you haven't seen it, go see it and go watch it. Called Judgment at Nuremberg with Spencer Tracy. I show it every year. I can watch it all day. There's a great line in the movie where a reporter is talking to one of the generals. And the reporter says that, you know, I couldn't give away a story on the Nuremberg trials right now. And he's right. Because what's happening at the same time that this verdict is being delivered in 1948? The world has shifted. Nazi crimes and that period have started to become secondary. What's become primary is the Soviet Union, the reconstruction of Europe, the Marshall Plan, which is going to come into effect soon. As soon as the verdicts are let down, and again, you got 14 death sentences out of this case, people are tripping over themselves, Americans and then eventually Germans, into trying to get these sentences dismissed, reduced, nullified. The Americans are under the impression that you're going to make the German people unhappy if you sentence more of their leaders to death. That it's time to almost not forget exactly, but it's time to focus on new priorities. Konrad Adenauer, who is the new Chancellor of Germany, makes it a specific point that if the Allies want German cooperation, one of the things they're going to have to do is start remitting and start reducing these war crime sentences. Clear choice. You want Germany, a modern, reorganized Federal Republic of Germany in 1949, this is what you're going to have to do. So whereas General Taylor is aghast at this and Ben Ferencz is aghast at this, it's exactly what happens. And as 1948 goes into 49 and 50 and 51, by the time we get to 51, we've reduced 14 death sentences to 4 at Landsberg Prison. So all those other people sentenced to death for all those million murders in places like Finitsa and other places where they don't even have names. Little Jewish communities where everybody has been killed. And by the way, that's one of the other reasons that Ferencz decided not to put on any witnesses. There weren't any victims left to testify. When the Einsatzgruppe comes into town, they kill all of you. That goes away. And new justice, new Reconstruction justice kind of takes its place. And one of the things, ironically, that Ohlendorf kept thinking was, I'm an economics expert. I know the Russians. I fought the Russians, or at least fought on, murdered people on the Russian front. Surely the Allies are going to want to take advantage of my expertise. He doesn't miss it by much. And come to it second, because I want to talk about what the trials mean or they don't mean. Ohlendorf, though, did miss the train when it left the station. Because in 1951, he is one of the 4 people that's put to death, hanged at Landsberg Prison, along with Paul Blobel, the guy that orchestrated the Babi Yar massacre. Nobody misses him. One of the other defendants sentenced to death is a colonel named Martin Sandberger. evidence of the Einsatzgruppen reports and the Jaeger Report put his personal tally of his Sonderkommando, which was a subunit of Einsatzgruppe A, at about 20,000 people. He operated, actually he lasted in the East longer than most of the other SS leaders. He volunteered to stay longer. He's sentenced to death in 1948. His sentence is reduced from a certain death sentence that probably would have been carried out if it had happened during the IMT trial. He actually served 6 years. He died 5 years ago at a retirement home in Stuttgart. He drew a state pension every month until the day he died. After the war, his law license, which by the way wasn't suspended, he's a lawyer, or was a lawyer. He got work with a German concern, and he made a bunch of money, and people just forgot about him. The German magazine Der Spiegel interviewed him a couple of months before he died, and he remembered some things with incredible clarity that had nothing to do with the murders. But when it came to murders, this is a picture that Spiegel took when they interviewed him, the bottom right-hand side. Yeah, he couldn't seem to recall those kind of details. If we look at this case in this series of cases as kind of an outlier, that this is something that they did to innocent people, I think we're probably missing the boat on that one. In 1962-63, a doctor at Yale, Stanley Milgram, conducted an interesting series of experiments on obedience to authority. You probably heard about them. Amazingly, few people, younger people now, no one has heard about these hardly, unless you study psychology. And you can take average, ordinary American citizens that are going to work for, one of the fee was $4 in 1962, put you in a room with a person, and you conduct experiments in reinforced learning. You ask the person who's strapped up to this device with electrodes some questions. And if they get them right, that's great. You ask them another question. But if they get it wrong, you're supposed to flick a switch and send an electrical current to them to help reinforce their learning. The box you're attached to, or the box you're operating, is marked from like level 1 to lethal level 50. How many people do you suppose would continue to administer electric, or what percentage of people do you suppose would continue to administer electric shocks all the way to a lethal level? Well, the experiment was conducted in 62, 63. It's been reproduced a number of times in a number of different locations, and the numbers are pretty consistent. Just over half of the people tested will continue if the person in the lab coat tells you to flick the switch. And these aren't Nazis 70 years ago. These are our people right now. It's a really disturbing study, and the fact is, I think if you conducted it a new one now and you started changing the math a little bit, and you had people administering shocks, and by the way, this is of course a setup, we're not really electrocuting people, they're actors. The person who's flicking the switch doesn't know that. But if you try to do it again now, and suppose you had them administering a learning reinforcement test to a group of people that they may not like very much, what do you suppose would happen? If you made them different, if you made them other, if you don't give somebody, ideological conditioning to get them to hate or to have the sort of the depth of dismissal that the SS had for the people that they killed. I think we would be very shocked by this. And it really isn't, I think, a 70-year-old thing. I think it's very much the fact that if you really want to, you can talent spot for good stuff, and I think you can talent spot for evil. If I work with a group long enough, I can pretty much pick, if I really want to have something done, I can probably identify who those people are going to be likely that will do it. And that's the frightening part to me about this trial. The legal part I get completely. The other part, I may never get this, and I don't know that maybe I shouldn't get it. But if we walk away and thinking that this is something in the past, it isn't. If you look, even going back to those three kinds of defenses we saw in the Einsatzgruppen case, if you pull the statements of the perpetrators of the My Lai massacre, or if you look at the investigations that were conducted in Rwanda, they're the same. Yes, I did it and I was justified in doing it. No, I didn't do it and you can't prove that I did. Or I kind of did something, but I'm really not gonna be very forthcoming about that. There is no distinction, and it doesn't matter. It doesn't have anything to do with nationality or religion or race. I think probably the fact is it's around. And maybe the better question is there a way to short circuit that? Which is probably another talk for another day. So if we're looking at the trial, how did we do? The sad truth is trials, by their very nature, aren't supposed to produce justice. I'm probably going to get pelted by lawyers for that, but they don't. Trials produce a result. You get guilt and innocence. In this case, you get guilt. You get clarity, you get some historical truth, you get a record of what actually happened. But whether or not these trials, the Nuremberg main trial or any of the subsequent trials, the doctor's trial, the IG Farben trial, whatever, produce justice, I think only is known after the trial is over. It offends me as a lawyer and as a person that Martin Sandberg was able to live the rest of his life on a pension and nobody cared about it. That doesn't seem to me, to whatever notion of justice you carry, I think that's probably not close to it. But the trials were important, and I can't even imagine where we would be in terms of, in many fields, if we hadn't had them, if we hadn't produced the evidence, because this stuff didn't come out during the IMT. If we'd stopped after the main trial, the picture we would have of what went on in World War II would be so incomplete, you can't even calculate it. So this did matter, and I think that if there's ever a lawyer's hall of fame, and there ought to be, we need to get some funding for that, so you need to start hitting people up, okay? So get on that. Telford Taylor needs to be in it, and Ben Ferentz needs to be in it. Because I think they did the best they could under incredibly adverse circumstances with something that really does qualitatively matter, and it should matter. What you got? Yes, ma'am. Oh, sure.
Because we are filming tonight's program for national television, we would ask that you please step to the microphone in the middle of the room so that we can capture your question for television viewers. So as you have questions, please head to the microphone, and Dr. Hull will hopefully be able to answer them.
Or not so much, and we'll find out.
Okay. First of all, I'd like to thank you for your presentation because it was very informative, and that type of information is not put out to the public too often, and it's really important because people have short-term memories.
Thank you.
The other thing that I wanted to ask you a question is, a friend of mine was looking up something, and she accidentally got on this website where they had all sorts of theories, and one of the theories that they discussed was that there wasn't 6 million Jews killed. They had like 800,000, and they were saying that, this could not be proved and that it was greatly exaggerated, et cetera, et cetera, et cetera. So my question is, as you put down, obviously there is some proof of some Jews that were executed. Do you know what the tally that we can say for sure that we know this many? We might not know 8 million, 6 million, but we can say for certainty that this number is killed and we can extrapolate the rest.
It's hard. I think that kind of precision probably is beyond us. With the Einsatzgruppen,
Okay.
you can say with pretty high degree of confidence what the number is. With the concentration camps, oftentimes the prisoners are brought in, they're not entered into the camp records, they're sent immediately to extermination. So the exact total, assuming it ever existed, might have been with the railroad system in terms of how many people are put on what kind of transport. But this is such a comprehensive biological extermination. It's happening with these mobile extermination squads. It's happening with Einsatzgruppe A. One of the things they had going for them was the degree of help they got from local people that are already, you know, spun up to kill people. The commandant of Auschwitz testified at Nuremberg that his camp had killed, he said, about 2 million, and I think that was probably a little bit too high for Auschwitz. Not by much, but a little bit. Shorter answer is we don't know.
Okay.
And we're never going to know.
Okay.
And I think, kind of going back to one of the things that Musmano said in the decision, the inability of our minds to absorb and to get around these kinds of numbers. I'm not even sure certainty would help out with that. But by the way, and it really disturbs me that people would start to quibble that it's only 800,000. I mean, for crying out loud, if you got Ohlendorf, who's been sentenced to death, that's still telling you, here's what we did. Okay, you know.
That's true. Good point. Thank you.
Yes, ma'am. Mm-hmm. And by the way, nobody that I work with is allowed to ask a question, okay? Because they may not. They're actually very mean to me during the workday, and I'm not going to give them a platform here.
Hi. Can you speak to why the Nazis quit employing the Einsatzgruppen and shifted their tactics to the death camps?
Simply because it was inefficient. The Germans, again, I think the better model of the Holocaust is kind of an evolving thing. The plan to do kind of universal biological extermination, I think, probably happened after the German invasion of Russia. Their inclination was fits and starts, and there's not really a straight line Holocaust story. Once they got into Russia and the Jewish populations were much larger, that's when I think the Einsatzgruppen were deployed and the need to kill these people. But they weren't enough. And even inside a highly indoctrinated Nazi system, you're not able to pony up enough people to do this by bullets. So they started, by 1942, they started experimenting with gas vans, and they realized that actually that in some cases is harder on the attendants, the SS, than even the shooting. So they got to come up with another system. And so after Reinhard Heydrich is killed in 1942, they set up a number of just purely extermination centers. Auschwitz was partially extermination, partially a main camp with different chemical companies or different industrial firms that worked at Auschwitz. Chelmno, Treblinka, those camps are purely, they have no camp population. They're purely to get people in to exterminate them and to dispose of the bodies. And that is a difference that happens really in 42 that even wasn't true with the Einsatzgruppe.
How many questions can I ask?
She's a lawyer, which means you should not trust her.
Not at all. I'm curious as to, and I didn't recall, I didn't really study these trials, so I don't know, but who determined the statutory structure, what the crimes were going to be, what the elements of those crimes were going to be, the fact that there really were no rules of evidence, who made those determinations?
The determination happens pretty late. It's in June 1945, so the war has just ended. Okay, the war ends in Europe in May. In June 45, they had what's called the London Conference. Russians, British, French, Americans get together, and over about a 3-week period, they hash out what's going to be the Nuremberg trial policy. The Nuremberg Charter, all 32 articles of it, I'm sorry, I can't remember how many articles, it specifies here's how the trials are going to work, and one of them is relevance is the only standard that matters.
Okay.
Numbers, I think Article 17 of that.
How did they select the judges? Why would they pick somebody who was an opponent of the death penalty?
By 1948, that's another problem because, again, the world had kind of moved on by then. They had trouble recruiting judges. The judges at the Nuremberg Tribunal were in some cases the best they thought they could get the main trial. In this case, they wanted people that would do it, which was hard, finding people that would actually volunteer to spend maybe a year trying a case. They needed people that knew how to write an opinion, which in the Army procedure you don't normally write opinions. So it had to be a civilian jurist that would do it. Sometimes you get what you get. Some of them were phenomenal jurists. The Judge Spite from Alabama had never been a judge before.
Okay, and then finally, I'm assuming that they had defense attorneys?
Yes.
I can't think of a worse job to have, but I do believe that in due process, who were they and how did they get selected?
They volunteered. Their fees were paid by a number of different organizations. The Americans would pay for a defense attorney. There's one guy named Rudolf Aschenauer who represents, I think, 100 and something war criminals over the course of his career. Some of them were very, very good. But the thing is, the German system is not like this Anglo-American system we have at the IMT. So they had to get smart about that fast. Some did, some didn't. They did have Army lawyers available too, by the way, to kind of to coach them.
They get any civilian lawyers to do that?
Almost, I think, in every case except one, all the German lawyers were civilian lawyers. They didn't get any U.S. civilian attorneys.
All right, I'll ask the rest of them later.
Does that end the question and answer session if the mic is blown? Okay.
Can you comment on the fact that while these trials were ongoing in Europe, the OSS and the CIA here in America were bringing over men who had committed equally heinous crimes, ostensibly to try to use them for questionable intel, and they discovered that they didn't have much to tell them, and then they set them free, and they lived next door, sometimes a block away from their victims.
Yeah, the OSS CIA plan was called Operation Paperclip. They brought over, I don't think anybody knows how many, people who had worked for the SS or the Gestapo or worked for the German government whose professed knowledge about the Soviet Union was considered to outweigh their criminal past. There are a lot of different examples. Klaus Barbie, actually, who was the butcher of Lyon, he was later convicted. He worked for the Americans. We brought over rocket scientists. In some cases, we weren't too particular about the ones we brought over. But again, it's part of the same pattern that after the war is over, political priorities shifted. And again, you get the result you get.
Thank you.
Yes, ma'am.
I guess that's my question, is more about the political priorities. So what do you think would have happened if we would have continued, the Allies, in enforcing the death sentences and not backing away from it? You said the Chancellor said he wouldn't participate. Explain to me what you think that would have looked like.
The issue in sort of the late 40s is German sovereignty. The issue, we wanted to bring Germany back as a NATO, or eventually not quite yet NATO, but as a bulwark against the Soviet Union, which was an active threat, the Berlin blockade, and so forth. And that simply was one of the priorities. In other words, to turn the process as much as possible back over to the Germans.
So we needed their economy to be strong?
We needed their economy to be strong. We needed a political infrastructure that was not Nazi, because at the same time we'd been doing an expansive denazification program. So as quick as we could, we're trying to sort of get out of that business, turn any prosecution of war criminals over to the new German government. The problem is, and we have the same thing, this is not a German-specific issue.
Sure.
People trying their own does not go well. You know, I mentioned the My Lai case from 1969. We seem incapable of actually handing out, you know, reasonable sentences to people of our own that commit crimes. There's a famous trial that goes on in Leipzig after the First World War in 1922, where the Germans are asked to put German citizens on trial for war crimes in the First World War. There's, out of a list of 900 suspects, I think 12 go to trial. Of the 12, 2 of them escape under circumstances that are kind of peculiar, like they just went to their house and they just weren't there, and we don't know where they've gone, and so they're dropped. None of them serve longer than 4 years, because you get into really some really hinky issues once you start asking people to pass judgment on their own when you still have what you consider, you know, occupying forces in your country.
So was our ability to impose conditions non-existent too? Like, for example, okay, they're going to be sentenced, maybe shorten their sentences. I assume that happened
Yeah.
too. And now they can't hold positions in government? Like, were there conditions we could put in?
Well, no, because eventually there's going to be just a general amnesty. The last of the Nuremberg defendants, and we convicted 185 out of the 12 trials. The last custodial sentence ended in 1958. You know, that's one of the kind of shocking statements. If you're seeing the movie Judgment at Nuremberg for the first time, is a little caption at the end that says none of them are still serving their sentences. And the idea that the best face I can probably put on it is to say that it's not our optimum outcome. Yeah.
Thank you.
Yes, ma'am.